We're off. So let's dive into remedial process, which is 3 chapters, one on what remediation is in greater detail and all of the preliminary matters, and then a chapter on trials, and then a chapter on appeals. So we start with the preliminary stuff. And again, I'll go over some of the significant changes, particularly ones that relate to PJCs and their work. There's a new opening section about the purpose of remediation and defining its limits and explaining file requirements and deadlines. The filing requirements and deadlines piece, especially the deadlines, is from an authoritative interpretation. And we'll look at some depth about what that is. That's D40103A is deadlines, and also with respect to methods of filing. We note that electronically submitted documents are okay as the rules permit, and sometimes the rules are permissive and say you can if everybody agrees to it. Sometimes they are definitely allowed, and sometimes they're not, like in the first filing of a complaint. It is required to be done the old-fashioned way through the mail, but there are some changes to it that we'll discuss. One of the big headaches that those of us who've used remedial process in the past have had to deal with is the different ways that it worked depending on whether or not a stay of enforcement was being requested. It was essentially 2 different processes. And in rules of discipline, if a stay of enforcement was not being requested, then the officers of the PJC didn't even see the case until the answer had also been filed. But if a stay was being requested, then they had to see it immediately, as the whole PJC did, in order to determine whether or not they were willing to sign a stay. So we changed that process and made it one process now in church discipline that starts at the beginning, and there's one set of rules along the way that you follow, one set of deadlines if you're filing a request for a stay of enforcement, and another set of deadlines for if you're not. But it's one process, and when the materials go to the officers is the same either way. It's just a matter of what they have to do with them when, and what the respondent has to do when, that have changed to try to streamline that into a single process. Another change we made throughout both of these processes is we put a little more responsibility in the hands of the stated clerks. And I know there are a number of you present in this meeting. For example, when a complaint was filed, part of what the complainant had to file with it was a certification that they had indeed sent it to the respondent. And that sometimes caused problems because they didn't do it, or they didn't do it the right way, and it became a problem processing the case later on. So now that has been placed in the hands of the stated clerk. A complainant sends it to the stated clerk of the council that's going to hear the case, which is the next higher one than the one they're complaining against. And the stated clerk has the responsibility to see that it gets to the respondent and everybody else. Ooh, I changed those. Give me just a second here. Okay. We also added a 5th preliminary question, or PQs as we refer to them. Those are the jurisdictional questions that get asked at the beginning of a case. And we'll be looking at those in some depth, and we'll talk then about why we added a 5th one. There were 4 in rules of discipline. There are now 5. Because of this one process that goes through, let me go back, in rules of discipline, when a stay of enforcement was being requested, the officers had to make a kind of a, not an actual ruling, but give advice to the PJC about what they thought the jurisdictional questions were, or how they were going to be answered, in order to inform them, the members, about whether or not to sign a request for a stay of enforcement. Because of the way it's now laid out in one process, the officers issue a preliminary ruling on the PQs within 10 days of receiving the complaint, regardless of whether there's a request for a stay or not. And then they have an opportunity later on to affirm or amend that decision. And this is a key piece to me, the respondent only has to compose an answer if the case is accepted or if its dismissal in that preliminary order is challenged by the complainant. Then the respondent has 30 days. What happened in the old process was that somebody files against a presbytery, you're pretty sure it's frivolous and they don't have standing, but you've got 45 days, you've got to get an answer filed regardless. And so you had to go through that process and do it. And it frankly wasted a lot of resources and time at presbyteries and sometimes attorney costs and everything else that goes into putting an answer together. Now you can wait and see whether it is in fact accepted before you work on it, but the deadline is 30 days instead of 45 to get it done. So it's a somewhat shorter timeline, but you're guaranteed of a month to put an answer together if in fact the case is accepted or the complainant challenges its dismissal. Questions about that? Okay. And then officers can either affirm or modify their preliminary ruling. So if on the basis of, now they have the answer and they realize, oh, this person doesn't have standing to file, we thought they did, but they don't. So now we can change it and create the final preliminary ruling, if you will, which of course can then be challenged again if necessary. We hope that will improve and not create stumbling blocks along the way. It's intended to give presbyteries enough time and other councils, but primarily that's where these were happening and getting held up. Valerie, have a question?
Just to make sure I'm tracking, we're still only talking about the clerk and the moderator of the PJC doing this work, making
Correct.
these preliminary rulings so
Right.
far. Okay, thank you.
Yeah. But now rather than a stated clerk of the council holding on to a complaint and waiting until the answer is received before they send it on to the officers of the PJC, they send it immediately. Within 10 days, they do what they can, realizing that they're only hearing one side of the story. And then if they dismiss it and that's not challenged, it's done. If they accept it or dismiss it and the dismissal gets challenged, then the answer has 30 days by the respondent counsel. Okay. All right. Counting time. There are a lot of cases in which the time for filing documents is a problem. And so this is essentially from the Yoon case where the GAPJC spelled it out very clearly in hopes that it would be used by the church in other cases, and it was. And so now we put the language in. So here's the official now constitutional language for how to count time when it comes to a filing. In determining whether a document is timely filed, the day following the event giving rise to the time limit begins the count as day one. And all 7 days of every week are included in the count, including holidays, and the document shall be deemed timely if it is received by the person or persons to whom it is required to be sent on or before the final day of the count. When the final date of the count falls on a weekend or a holiday, the document shall be deemed timely filed if it's received the next business day after the final day of the count. Just to be clear, let's look at a calendar and count. And I can't tell you how many times on the GPJC, the moderator and I, as clerk, literally got out calendars and counted 1, 2, 3, 4 to make sure we were at the right place. I took one of the short ones because it'll be easier to do, which is the 10-day limit for when the initial preliminary ruling has to be entered. So complaint was received on Monday, August 28th. Day 1 is the 29th. Go through to 10. It's due no later than the 10th day, which would be Thursday, September 7th. Now let's take another scenario. The complaint is received on Thursday, September 14th. Then when you count to 10, day 10 is a Sunday. So September 25th, Monday, the first business day after that, is the final date. Everybody clear? Okay. Andy?
Actually, I do have a question. Is when it says business day, does that mean commonly defined business days or business days of a council in the system? For example, the Presbytery of Greater Atlanta is not open on Fridays.
There are some additional authoritative interpretations that talk about receipt, and it's clearly the case in other councils too, that increasingly there are part-time staff and times for doing that. So that may be a gray area that continues to evolve. It's one of the reasons that we wanted things to be available to be done electronically, where you can demonstrate the day it arrived and was sent, and confirm it ahead of time. So, it says what it says, and we'll have to just play out with that. Do you assume it arrived on Friday because it was there Monday morning when you walked in? That's just something that can be a judgment call you have to work with. But you can see that that's why sometimes these things get sticky. And it's helpful for people to work ahead of deadlines. One thing I've learned about attorneys over the years is they know when the deadline is, and they tend to put their work together such that they meet the deadline, but not by a lot often. So that's the way it works. Okay, stays of enforcement. There are actually 3 ways that they can be obtained. The first 2 are essentially the same, but at different levels within a case's life. The third way is by far the most common one. So the first one is a third of those present at the meeting at which the action or inaction was taken can request or can require a stay to be signed. So you're at a presbytery meeting, the presbytery does something that a lot of people think is a constitutional violation. If a third of those people sign a stay, then that meets the requirement. Conversely, in an appeal, and we're not to appeals yet, but if we were, in an appeal, the request signed by a third of the members of the PJC that issued the ruling can stay it. So it was a controversial PJC meeting and decision, and a third of those present think it needs to be stayed while the next higher court reviews it. They can sign it. The third way that is much more common is the complainant can request that 3 members of the PJC that's going to hear the case sign it. And so that's what led to rewriting how we do the remedial process in the rules, because it's quite common for people to ask for the action that they think is unconstitutional to be stayed, which means don't act on it until the process is done. And the process, again, if requested, that it be signed by 3 members. The PJC has 10 days to do so. Now note, the officers have 10 days as well to give their preliminary decision. So it doesn't leave a lot of time to take that into consideration. In retrospect, I kind of wish we'd gone a couple more days for the stay, but we felt we needed to keep it at 10 because when an action's been taken, if you're going to stay it, if you're not going to stay it, then it needs to move forward with whatever the action was. So they're both at 10 days, which means you could be on a PJC and be struggling with whether I'm going to sign this or not. And at some point during the day, you get the word of what the officers say about their first look at the preliminary questions. And then you take that into consideration and later in the day, sign it or determine not to sign it. So that's how the new process is going to look. Donna asks, is that midnight or 5 o'clock? In order to be received by a certain date, if it's in the mail, it would have to be delivered on that date, which, by the way, is another piece of that. If somebody sends something by certified mail, then there's a receipt of it date that is known. Bill.
Two things. Oddly, just went through a thing arguing about when something was received, and it turned out the mail carrier had signed the receipt for both the respondent and for me, which was kind of awkward. But on the stay of enforcement stuff, in looking in 40601, it sounds like the stated clerk gets statements signed by different members of the PJC. It doesn't sound like there's a meeting of the PJC to decide on whether to do the stay, but the wording sounds like if the stated clerk receives 3 or more statements from members of the PJC, the stay shall be granted, and then it gets sent out. So, but I thought I heard you talking about the PJC having a meeting to decide the stay. What did I miss?
No, they don't meet on the stay. The individuals have to determine that they're going to sign it. And there's no rule that says they can't talk amongst themselves, but it would not be a formal meeting.
So the follow-up is if the 3 of them all agree on, like, if they ask for 3 things in the stay and people agree on 2 but not the 3rd, they get the 2 but they don't get the 3rd, right?
Correct.
Okay.
Yeah.
Thank you.
And they don't have to have the same reasons why they think their rationale for it. But yes, it is the case. And there have been cases where some were willing to stay parts of this, but not others. And others were willing to stay the whole thing. So yes, that is very much the case. It's only that on which at least 3 members, you could have 8 members who all pick different things. And between them, maybe there is concurrence on part. So that's just something the officers have to work through, is who did.
Thank you.
Yeah. Anybody else? Okay. As I said, must include summary of specific actions or decisions being stayed. That's so that work can happen. You can't just sign it and say, yes, I agree to the stay. You have to say what you're agreeing to be stayed so that can go on. And a statement that in their judgment, and this was what does not have to be the same from person to person, that substantial harm will occur if the action or decision is not stayed and there are probable grounds that exist for finding the decision or action erroneous. And those are actually pretty high standards when all you have in your possession is a complaint without an answer. But that's the nature of stays of enforcement. And that's also why a decision can be challenged. If it is entered, then the respondent can challenge having a stay of enforcement and get a chance to get before the commission and perhaps change their minds. Okay. I'm reading a note I wrote to myself, and I'm not sure why I wrote it. Okay. So preliminary ruling and PQs. This is what the officers have to look at to determine whether this case is going to go forward. And it is in D40501, examination of papers, is where the preliminary questions are listed. The first one is the council has jurisdiction. That means this is filed at the right place. And it's kind of surprising how many times they aren't. So it may not be properly before the presbytery. It may be about a presbytery action and it's properly before the synod. So you have to determine first, is this the right council level? And second, and I guess along with that, the way attorneys say it, it's ripe for adjudication, meaning it's an action that can be taken or that was taken that's appropriate to be in a judicial process. That especially happens on appeals where people want to appeal something, a ruling that got made by the court before the court has made its final decision. And they want to appeal it in the middle of the process. And the deal is you can't appeal something until it has been finally decided by the PJC. That final decision could be not to hear it, but that's a final decision. Second, one or more of the complainants has standing to file the case. That's a slight wording change from rules of discipline that just said the complainants have standing to file the case. There have been instances in which not everybody who complained had standing. So the reality is if at least one of them does, then they meet that criteria. Okay. And then third, that it was timely filed. And that means 30 days if a stay of enforcement is being requested. And it means 90 days from the date of the action if a stay of enforcement is not. And here is the fourth question, which is the new one, which is really an attempt to clean up the fifth one. The fourth question is the complaint alleges facts that, if proved true, would constitute an irregularity or delinquency. It's kind of, the way I look at it, the remedial equivalent of the old D100202A disciplinary. The first thing an investigating committee did in its process, and still does, but in an even more preliminary process now, is determine whether an actual allegation of a violation of scripture or the Constitution exists. So in other words, you know, they file something against their minister who they think is giving bad pastoral care, but they can't articulate where they violated scripture or the Constitution in doing that. So NIC has the authority, this is in disciplinary, not remedial, to say, no, they don't allege an offense. So therefore, we don't have to go through the investigation. This is kind of the equivalent of that. If the facts that they allege are proved true, then was an irregularity or delinquency committed? And that's because the fifth one, which is that the complaint states a claim upon which relief can be granted, which is all the old book said, was widely used to answer the new question 4. So we decided it would be cleaner to look at it this way. So I just want to show you in doing our work, often what we did was go to the annotated book and look at where there were a lot of AIs. So if you go to the old rules of discipline, and this was 60300 in that process. So the complaint shall state the following. The 60300 is where it said. No, that's what it contains. That's not the. Well, shoot. There. Examination 305. So in ROD, examination of papers has a few. Jurisdiction has quite a number of annotations. Standing has a number of them. Timely filed has a few. Now, the complaint states a claim upon which relief can be granted. That's how many authoritative interpretations there were on that section. So that said to our committee, we have got to work on this and try to clean up what it says and what it means. And so the new wording, instead of just saying states a claim upon which relief can be granted, says, clears up a couple pieces. One, permanent judicial commissions may but shall not be required to proceed to trial when they determine that the relief requested cannot be granted, but that there is potential relief, declaratory or otherwise, that could potentially be granted. So it shouldn't have to be a PJC's job to invent relief that can be granted. They can, and many courts do, but they cannot be required to. Declaratory relief is something that really is not appropriate anywhere but at the GAPJC level, because that means relief that doesn't change anything, but it states this is the fact of how this should be interpreted. In fact, those can often become authoritative interpretations of a text in the Book of Order. And it's important for them at times to say that when something is moot, when it's too late now to unordain somebody, but here's the declaratory relief we're going to grant, that should not have happened, and here's why. But since courts other than the GAPJC issue rulings that are only binding on those parties, declaratory relief really doesn't make much sense at the other levels of the church. But you can still do it. It's just that you can't be compelled to do it. It's not a reason to sustain an appeal and send it back to do it over again. And then we gave also some examples of relief that cannot be granted. So relief that a council may not grant includes but is not limited to, and we list some examples of those, and those all come out of AIs that were in that long list. So hopefully that will help clear things up, first by creating a separate question about, does it really allege an irregularity or delinquency in the first place? And then second, here are some kinds of relief that cannot be granted. Any questions? Also, summary judgment, matter of law, not of fact. Bill, you want to say more about that? That comes from the secular legal
Right.
language.
It's just the way some things go away, because I mean, it may or may not be right or wrong, but there's no actual violation. And that's how it goes away. That's another term that goes with that. On the declaratory relief, is this where a PJC might say, in effect, we can't do anything about this, but we think it was a bad idea to go that way, or something? Is that the kind of declaratory relief they might do?
Yes, they can say this is moot because the position no longer exists, so we can't reinstate somebody to a position that's not there, but you shouldn't have done it that way.
Right. That's what I was thinking.
Yeah.
Thank you. Just, I mean, we'll find out over the next few years what people do, but I was trying to think of something they might.
Jimmy L, can you say a little more? You want to know a discrepancy regarding delinquency? I'm not understanding what that means. Can you?
So when you were citing an example on number 4,
Mhm.
the example, unless I heard it incorrectly, was for wasn't for remediation. It was in relationship to discipline. So I was wondering if you could cite an example of where something that occurred within the presbytery that now a complaint alleges of the
Yeah.
fact that see what I'm saying?
I'll give you a well-known one in at least GAPJC cycles. It is a case called Kuipers. Um, a woman who is now a member of National Capital Presbytery, but she filed filed against her session for not taking to the congregation for a vote a decision to create an endowment fund. There's no constitutional provision requiring a congregational vote on anything like that. Eventually, it got tossed on preliminary questions, and there was never a trial. I think that may be a good example of saying there's no irregularity alleged. She thinks that congregations ought to have to vote on establishing an endowment fund, but that's not the case in our polity.
Okay, I
One
appreciate
stuff's fine. So you're right. The example I gave was about a minister doing poor pastoral care, maybe, and yes, that would be more on the disciplinary side of why an IC might throw it out, but not a remedial side. So something about an action that someone thinks should have to be taken, but it's not in fact in the book, would be an example of that.
Okay. Thank you.
Yeah. Okay, now it's time to have a little fun. The papers that you were supposed to have gotten downloaded in front of you, the one that has documents 1 through 4. We're going to start with document 1. And what I want you to do is use the preliminary questions and assume that you are the officers of your PJC and discuss together after you introduce yourselves. These are randomly assigned groups, so it won't be the same group you were in before. So we're trying to help you all get to know some colleagues around your synod as we do this. So introduce yourselves, say where you're from, and then go through the preliminary questions and talk about how you would answer each of them. And you will have 10 minutes. And Andy, take it away.
All right, you have 10 minutes, checking all my settings here, and let me pause.
Okay, looks like everybody's back in.
No.
Please mute yourselves. And so I want to go through the preliminary questions, and I want to do it with a raised hand feature. Do you all know how to use raised hand feature? It's under the word reactions on the toolbar. If you click on reactions, then there's a raise hand. And that's where, okay, good. And now I'm going to lower everybody's hands. Not the one that goes like this, but only the raise hand one that goes up. So it's the one that says raise hand. Okay, so preliminary still got people figuring it out. Okay, give you a second. Clearing all feedback. Okay. Does the council have jurisdiction? All those who think in this case the council has jurisdiction, raise your hands. Okay. I'm going to clear that out. That was 21 yes, 22 yeses. All those who think the council does not have jurisdiction. So few of you want to argue that. You want to say anything about why? In answer to Bill's question, there's a whole lot that's missing in this. That's kind of the intent of this little exercise. But okay, so we got about 5 who say no.
I didn't raise my hand because I couldn't tell the answer.
Yeah.
Yeah.
Now I realize that too.
Yeah. Okay. Second preliminary question. One or more of the complainants has standing to file the case. How many think yes? Okay. About 20 or so. Let's clear that out. And how many think they do not have standing? Okay. So, you know, there's one. I think the simple answer to that at the moment is we have to make an assumption to know that anybody does. All they say is we're a ruling elder and a teaching elder, but they don't say teaching elder of this presbytery. And is it filed correctly to this presbytery? And, you know, is the ruling elder, just because you're a ruling elder doesn't give you standing to file necessarily. So it depends on where you are, to what meeting you were an elder or whatever. So you have to read the rules on jurisdiction. And by the way, obviously this piece that's been used in training for years, by the way, is intentionally vague to point out the things that really need to be in a complaint and why. So timely filed. How many think the complaint is timely filed?
Parts of it.
Parts of it. There we go. Let me just jump in and stop this one. So here's the deal. They are filing this as a complaint with a request for a stay of enforcement. So what's the deadline for that? Anybody?
30 days.
30 days.
There you go. 30 days. So none of this is filed with anything close to 30 days. The
Except
actions alleged are to from December 26th, and then the first one September 1st, and it is now February 1st. So February 1st is more than 30 days from any of them, but it is within 90 days of 2 of the actions, but not the original one. So, you know, if you're going to accept this case, if everything else turns out to be correctly filed and so forth, the actions that could be considered are the decision to take original jurisdiction and the decision to dissolve the pastoral relationship. But no stay of enforcement is in order. Action talk. Well, when was that? Enforcement against the administrative commission for action blocking. Oh, I'm sorry. On 20. Okay. On 27. Okay. I stand corrected. So they additionally took an action on January 27 to take for to stay a meeting on February 8th. And January 27th to February 1st, yes, that is within the 30-day deadline. So
But the action is the calling of a congregational meeting.
right. The action is
but
calling a congregational meeting on January 27th is within the timeliness deadline for a stay of enforcement.
But can the
And-
session call it since there's original jurisdiction has already
Correct.
been taken?
Correct.
Right, there is no session. It's a group of people
Right.
who would have been on this session if they had one.
The administrative commission didn't call
I'm
the
sorry,
congregational meeting.
Well, it depends whether or not they were given that power. I mean, we don't know what the powers of this administrative
Yes.
commission are.
It says they were
That's
given-
the bottom line.
They were
So-
given they were given original jurisdiction. That's in the second paragraph.
Oh, okay.
Yeah. Yeah.
But
So
were they
back to
rightfully
my
given
original
jurisdiction?
statement. Yeah, there's no action that can be stayed because they took original jurisdiction, which means the administrative commission is the session. Yeah. There are a bunch of materials that go along with this training piece, and eventually what you learn is they want to leave the denomination. And the administrative commission had to move
Bye-bye.
quickly to block the actions of the congregation meeting to say we're disaffiliating with church, and it was over church property, and that's what eventually was going on. But in terms of relief that can be granted, who thinks there's something in this, not knowing what I just now told you, but just from what's filed already, relief that could be granted? Can a decision to take original jurisdiction be overturned? Raise your hands on that. Do you think a decision to overturn an original jurisdiction action could be taken and reversed? So therefore, it's an action that a commission could grant. It's relief that could be granted. Okay. Some of you, yes. I'm going to clear that. Who thinks that is not relief that can be granted? Okay. You want to say anything? Put it in the chat about why you think it cannot be granted. The statement in the Book of Order about administrative commissions says that actions of the commission can be reversed by the presbytery at a later date using our processes, namely the Robert's Rules of Order motion to amend something previously adopted. So you could argue that there are certain things that could not be undone, but personally, I think assuming original jurisdiction and setting aside the session is an action that could be contemplated under the regular rules, that is, without a PJC action. And then the question is, what can you do about it? If you're not a member of the commission, you have to have standing at the presbytery because an action of a commission becomes the action of the presbytery. So if you're an ongoing member of a presbytery, that is a teaching elder or a ruling elder, and this is another piece in jurisdiction that is stated clearly in the new rules, is that this comes from a decision of an AI that had an elder who her session had elected as an elder for a whole year to the presbytery, but she did not show up at the particular meeting where the action she was challenging took place. And the ruling was that there are two kinds of elder enrollments. One is commissioners from sessions who are enrolled for the specific meeting that they attend. And then there's the provision that says elders can be enrolled for terms of service, which many presbyteries do for those serving as moderators of its entities and for commission pastors and others. Those people are enrolled for the entire length of their service, so they would not have to have been physically present at the particular meeting. So they're not a member of the commission, so they weren't present there, but the presbytery, they have standing and presumably could do that. Or they could, at the next presbytery meeting, move to amend what was previously adopted on if they had constitutional grounds to do it, if they didn't go through the process for how you correctly assume jurisdiction. And if the presbytery didn't act on it, then that could become a delinquency against which they could file. So there's a process for, you have to put them on notice first, and then within a certain number of days, they have to act to cure the delinquency. And if they don't, then it can be filed against. So these things, even a quirky one like this can get complicated in terms of what's the right thing to do and what's the right decision. And that's why we have both original processes and appeals, so that those can be thought through by numerous sets of eyeballs before a final decision is made. Bottom line, as was said by Teresa in the last comment, we don't have enough info. This one is just very devoid of that. We are now to our 1 hour break. And at the end of that, when we come back in 10 minutes, we'll do another one where you have more details and take a look at one that's a little more fleshed out than this. All right. Let's move to document number 2. This time we're going to give you a little more time because there's a little more to read and figure out. But this is a more complete complaint, if you will. It is document 2, Reverend Humble Servant v. Peace and Light Presbytery. And so, Andy, same scenario. Your group, introduce yourselves, because again, it's a random group. So hopefully you're getting to know some of your colleagues better, and discuss the PQs. You are officers of your PJC.
All right, you know the drill. Enjoy your breakouts.
Okay, welcome back, everybody. So let's go to where we were, and the preliminary questions are before you. Let's try to speed this up a little bit and just do it with one set of reactions instead of 2. So if you click on reactions, one of the options is green check yes and a red X no. So use the green and the red to say whether you think that particular question is answered affirmatively or negatively. All right. Question 1, does the council have jurisdiction? Okay. 24 say yes, 8 say no. If anybody wants to say why, they can do so. I'm going to say it's an action of a commission, which makes it an action of the presbytery. It is a minister member of the presbytery, and he makes that clear. And it is filed with the synod. So the council of jurisdiction for an action of a presbytery is the synod in this case. He does not have not a member of the Commission on Ministry, but that action is an action of the presbytery. So that's where I would come down on that one, but these are not always clear. So AC's actions have been affirmed by the presbytery. So yeah, there's some question when, clearly when an AC takes action, it becomes the action of the presbytery. That doesn't mean that you can't attempt to have the presbytery change the action and avoid judicial process. But I don't think it requires that you not use judicial process. It just, if you go back to the preamble, you would be saying, let's try to keep this out of a court filing by trying another way. But we don't all have to agree, and so that's fine. Moving on. Second question, one or more complainants has standing to file the case. Green for yes, red for no. Okay. We're pretty much in agreement on that one, that yes, he does as a minister member of the presbytery. The complaint was timely filed. This there it is. So I don't have the timestamp on this, do I? So that creates some question of whether it is, we don't know when it was received by the presbytery or synod. So we need to know when the synod received it in order to know whether it is timely filed, right? Although if the action was taken on the 6th of May, and June, July, yeah, we're past 90 days. So if it was not received within that time, that's a possibility. So it depends on when they received it. And it alleges facts that, if proved true, would constitute an irregularity or delinquency. Yes or no? Okay, fairly divided. So the question here, which probably is the real heart of the matter, is does a commission on ministry have a constitutional right to issue what he calls a reprimand that may dial down to the facts of what actually they did? Does a presbytery have a right through its commission on ministry to what's the respect to the calls that they weren't allowed to modify the agreements for pastoral service, and he was denied the ability to do that. There are some AIs on that issue that say, yeah, presbytery has the right to say, no, we're not going to let you serve that church. So that one is less likely at least to hold, but it might get adjudicated if the other pieces fit. And final, states a claim upon which relief can be granted. What's the relief he asks for? And what, in fact, would the Synod have the right to change and grant? Yeah, it's noted that we don't really know yet what COM did. So that becomes what you have to look for in the process, and listen to the answer and see where you go. But if a COM essentially took a disciplinary action without using the rules of discipline to do it, there's a chance that they overstep their bounds. And also, what rights, as somebody pointed out, does the COM have in their presbytery? What authorities has it been granted? So you have to look into those. Donna says G30109, however, allows people to be heard on issues that affect them, and the moderator denied meeting with the pastor. Yeah, there is discussion of he asked for a meeting and didn't get it somewhere in the process. But again, what's the reprimand? That, what does that mean? That's not an official constitutional language. So that might boil down eventually to what was said and done. This, by the way, was an actual case, but it never got adjudicated because it was not timely filed. And so it got tossed on that one, and nothing else ever came of it. Just so you know. Names, of course, were changed. Minuteman was not the stated clerk of the presbytery. Yeah, there's also mention of a request for vindication, which he says is also being filed with the presbytery, which would be the appropriate place to file that. So that's a different matter that just kind of muddies up this issue of whether COM overstepped its bounds with some action. Okay, thank you for engaging in those. Hopefully that kind of makes it real, because these are the kinds of issues that at least your officers, and often through a request for a stay of enforcement or something, the full membership of PJCs have to deal with. These are the kinds of filings you can get. Sometimes they're very incomplete. Sometimes they're complete but still confusing. Sometimes they're in dealing with gray areas. And again, part of our preamble language says, yes, we use the process. If it's filed, you have to process it, but that doesn't mean that along the way you can't be helping people come up with opportunities for how to settle these, and not go the full route of an expensive trial and counsel and all of that. But in terms of filings and getting to the next place, that's what preliminary process looks like. That's what the officers have to do and deal with. Any other questions anybody have? Bill notes that requests for vindication can also backfire on the requester. Yes, it can. We'll talk specifically about that when we get to disciplinary. later on. Okay, moving on. We've got less than 30 minutes on today, so let's just see how far we get. We move on now to a trial. So we assume that with whatever our process is, it got through that set of preliminary questions, and now there's going to be a trial. What do you do? So if you look at the trial chapter, which is chapter 5, let's just kind of walk through. First thing you do is build the record of the case, and that is largely a stated clerk function. So it begins with duties of the respondent stated clerk. You get these materials submitted in writing to the parties, a list of the papers that are going to be included, and then the parties get an opportunity to amend that list. And then upon notification of the stated clerk that it's been accepted, the clerk or stated clerk of the respondent councils transmits to the stated clerk of the higher council without delay the items that are on that list. So you create a list first, you agree on the list, hopefully, and then once it's been accepted, you build that list, and that becomes the initial record of the case. Next says that the PJC may require briefs from the parties. I'm not sure I know of any that didn't require briefs, but it's may language from the PJC. And it also says there may be a pretrial conference in remedial. That's mandatory in disciplinary, but in remedial, it's still a may. So, depending on how simple the issues are, and clear they are, maybe there's no need for a pretrial conference. But if you look at the language of pretrial, the purpose of it is to seek agreement on a statement of facts and disputed issues, to exchange documents and other evidence, and to take other action which might reasonably and impartially narrow the dispute or expedite its resolution. And typically the moderator or clerk, but it says the moderator or clerk or their designees shall set a date and place and time for the pretrial and conduct it. So this is not the full commission. It's the officers or their designees in church discipline. It often was done that way. And so we just put it in as assume this is a small group, not the full commission that's going to do it. And it gives a chance to narrow the issues. So there may be 6 or 7 issues raised, but maybe you can come to agreement on a few of them and only have a few that are left disputed. And those are what you need to deal with at a trial. And then it says you conduct the trial formally and with full decorum. A lot of people know what that means. Some of you may not have a clue what that means. Here is a page from the old judicial process manual. It's a diagram that was in there to say, how do you set up the room for one of these things? And this is a pretty typical way you set it up. So I hope you all can read that. I don't know how big it is on your screens. Pretty small, and it was a little blurry even in its original version in the manual. But the top 3 tables are the PJC members. So we're assuming this is a presbytery PJC of 7 members. So there are 1, 2, 3, 4, 5, 6, 7 seats, moderator at the center and clerk beside them. And then the 2 tables along the sides are one where witnesses would sit, and the one across from it where the court reporter, assuming you're using one, would sit. The new rules allow for electronic recording. It just has to be in such a way that it can be transcribed. The good thing about a court reporter, they cost money, but the good thing is they will transcribe their own stuff. And so you don't have to pay somebody or get a staff member or something to transcribe everything that's said. And then there are tables for each of the parties. So you get the complainant or the person prosecuting committee, if it's in disciplinary. On the other side, the respondent or the defendant. And Then stated clerks or their designees are also to be present in these proceedings. And so there's a stated clerks table. That's the one in the back. And there's a podium in the center where whichever party is speaking would go. So that's where the complainant or respondent would go to when they have something to say. Typically, the rooms I've seen set up have that podium where either of them can get up and walk to it in the center instead of having it up so far where it's kind of in the way. But on the other hand, if they're questioning witnesses, they need to be where the witness can see them clearly to be asking the questions they're going to ask. And then room for some chairs in the back. One of the questions in our scenario said, oh, no, you haven't dealt with that one yet. Well, that's a question, is how many people you let in? And, you know, what if a whole bunch of people want to come? There were a couple of times on GAPJC when we were dealing with pretty high profile cases and a bunch of people, including press, wanted to be there. And we had to set some rules for what we were and were not going to allow. And that's basically up to a PJC to deal with. Any questions about that? Okay. The next section is citations and testimony. Citations are sending out a notice to someone that they shall appear before the commission on such and such a date to be a witness. We have certain authority in that regard to our own members. We have no authority over anybody other than our own members to cite them, but there are rules for the stated clerk sending those citations out. The reality is we have no real way to enforce it. And so the old rules, there was something called a second citation. If a person refused to come the first time, you send them a second citation. And if they refuse to come that time, then they're open to discipline. Well, the problem is rarely were people who were in that circumstance under the jurisdiction of anybody that was a party to the case or the counsel in particular that was hearing it. So, okay, they can be liable to discipline, but only if you can talk their home church, if they're a member of a church, or their home presbytery, if they're a minister, into proceeding with it. So we were unable to find of a single instance where a second citation made any difference. Somebody either came or refused to come, and that was it. So we just turned it to one. Testimony. Testimony is traditionally was done for those who could not be present in person at a trial by something called a deposition. The problem with depositions is that attorneys have a different understanding of them than non-attorneys. In the secular court world, they're done as part of discovery, which is a process that we don't have or use. Our submitting documents and turning them in and building the record of the case, that's discovery as we do it. In the secular world, there's a whole discovery process, and depositions are taken from which you then decide what you want to use or not use in evidence at a trial, or where you want to go at a trial in questioning. So we felt, and we have gotten some pushback on this, but it made it through the process and it's still in, that taking depositions out entirely from our process made sense for us, and allowing electronic testimony to come when someone cannot physically be in the room when we need them to be there at a trial is an adequate replacement for that. And we set the terms for it. It has to be requested. The PJC has to grant it. And it has to be in a way that meets the Robert's Rules standard for simultaneous oral communication. But with that, it can be done. How does a trial proceed? So we create at the beginning of this process something called a committee of counsel. That's what a respondent does. It creates a committee of counsel, and the committee of counsel is responsible for the process. But that doesn't mean that they are the counsel who represents the presbytery, say, at a trial. It's perfectly acceptable, and very often, in fact, at least at the GAPJC level, almost always the case that people hire counsel, typically attorneys, but they don't have to be, to represent them in the courts. So even a committee of counsel of a presbytery would likely hire someone, probably who's a trial attorney, to be the one who represents them in the case. So counsel do not need to be attorneys. They do need to be PCUSA members, and their membership needs to be verified. So that's part of what you do if you're a PJC getting ready for a case, is ensure that all the people are in fact members of the PCUSA. And if they're attorneys and not ministers, which often is the case, that can take some work to fact check a little bit and ensure that they really are active members of a Presbyterian church. In both, you're going to find the reason we're moving slowly now and going through all this is that when we get to disciplinary, it's the same language and we won't have to do that. But there are statements in both that say the parties cannot circulate materials to or communicate with others or with members of the commission. You have to do it in the correct way, which is to submit it to the commission. The commission decides whether it's going to be circulated, and that's how you do it. There's also a reading in here about what attorneys call ex parte communication. You can't communicate with one party, you have to communicate with them both. So the way materials and communications happen has to be on the up and up, and you have to be careful about it, especially if you're a PJC officer who has to do some communicating back and forth with parties in preparation for something. You have to ensure that you don't get into any content stuff. You're just dealing with process. So question, is there any timeline on how long they have been an active member to be counsel? Yeah, I mean, in theory, somebody could join the church on Sunday in order to represent the presbytery on the next Tuesday at a trial. There's no timeline. It just says you have to be one of us in order to be in that place in the room. Letters from clerk of, yeah. So this is, in our case, we had letters from clerks of session regarding attorneys' membership. So that's what I mean about fact checking, is you can go as thoroughly as you want. You could require a letter, or you could just do the verification. My best recollection in GAPJC world was that we had our staff investigate that, and they would make phone calls and ensure that the person was a member of the church in good standing that they said they were a member of. So, you ask them, are you a PCUSA member and where? And they tell you, and then generally speaking, you can verify that. Control conduct of trial. So there's a clear statement that PJC has a right to control the conduct, and specifically the role of the moderator is well defined. The moderator shall have full authority and power to control the conduct of the trial and of all parties, witnesses, counsel, and the public, including removal of them, to the end that proper dignity and decorum shall be maintained. Rulings of the moderator related to control of the trial are subject to appeal to the full commission by any member of the commission, which shall decide the question by majority vote. So that's a place where we put Robert's Rules language into the rules, just to make it abundantly clear that that's how we do things. So somebody has to make a ruling, and it's the moderator who does that. But that ruling, any ruling they make along the way, is subject to appeal. Questions about that? Okay. Moving on. And then the next section says questions as to procedure. 50504. Or the admissibility of evidence arising in the course of a trial shall be decided by the moderator after the parties had an opportunity to be heard. A party or member of the Permanent Judicial Commission may appeal from the decision of the moderator to the commission, which shall decide the question. So on admissibility and other procedural questions, not just the members of the PJC, but the parties can also object, in which case, again, it goes to the full PJC to handle. One question would be how you handle that. On the GAPJC, when I served, when one of those happened, we stopped the trial or hearing. We had only one trial the whole time I was there. We would stop the hearing and clear the room and handle it essentially in executive session, which we have the right to do, so that whatever debate occurred didn't become fodder for future, oh, that's the person that argued against it. We just wanted the decisions to be announced at the end of where we came out. So you have the right to do that if you want, or you can just do it in open session with the parties and everybody else still there and seeing what's going on. Question, what is the latest version of Robert's Rules? The most recent version of Robert's Rules that is in effect is the 12th edition. It looks like that. Has the beige cover to it. Guidance such as a guide for judicial process for sessions and clerks of sessions. Is there guidance such as a guide for judicial process for sessions and clerks of session? Sessions only, first of all, deal with disciplinary matters. So the first level of a remedial case is the presbytery, because they're filed against councils, and filing against a session would put it at the presbytery level. So one piece is that would only be disciplinary. And the second is, yeah, the stated clerk's manual for judicial process was intended to be used at every level. The problem is it was based on rules of discipline, and we're now going to have to wait for it to get revised to church discipline before it will be available to the church. But that will happen. It just hasn't happened yet. There is a section on absences and loss of quorum that says if you must be present in person at trials, and that needs to be, by the way, I have a list of potential amendments I'm working on to these rules. Actually, when we wrote the first version of church discipline, it was before COVID. And so into and through COVID, we decided that we really did have to allow for electronic trials, though we didn't want to. COVID proved that there could be occasions when you have no choice. And so our amended version that went finally to the General Assembly attempted to catch all of the places where it needed to say, if in person, but electronically, no. So this phrase really is kind of out of place now. It says members must be present in person at trials. What that needs to say is they must be present at the trials in whatever form the trials are being held. If they're electronic, then they can be present electronically. So that will get fixed, but I think you can assume that that's the intent, is to say they must be present in person if it's an in-person trial. But if it's an electronic trial, they can be present electronically. And the absence of any member after the trial has commenced shall be recorded, and that member can no longer participate. So if somebody has an emergency and has to leave for an hour, that's it. Which means you can have a loss of a quorum. And a loss of a quorum, minimum of which is 5 for a presbytery now, shall result in a mistrial, and the case shall be tried again from the beginning at a time and place to be determined by the PJC. So if you get to that point that you lose a quorum in the middle of a trial, sorry folks, but we have to stop, and we will start over again later. witch's argument to ensure that there are plenty there to have a quorum anytime you have a trial and that you're not close to it. Any new questions? I don't think you've covered this, and I don't want to forget to ask, is there or will there be update in the wonderful judicial process forms? I have no answer to that. I think there used to be a whole set of printed forms that were in the annotated book of order when it was a physical book. And you could use those forms for processes. Then for a while, at least, they lived on the OGA website. And whether they are still there, I don't honestly know. And whether if they do, they would clearly need some updating, because to the best of my recollection, they quote some rules of discipline stuff for filings. So I don't know a good answer to that. They are on the State Clerk Association website, or they were. Okay. So that's one to which I don't know the answer. I'll make a note of it, and I'll have a conversation with Lori about that at some point. Do they want those updated, or are they still useful? Interesting. Thank you. The trial itself, all that has been getting us up to, okay, now we're going to have a trial. We open it with prayer and reading of D1. Then you deal with objections, and then you deal with other various preliminary things. Any actions that were taken along the way have to be affirmed. So, when the moderator ruled on something that some counsel filed as a preliminary matter, then affirming those actions and rulings is part of what you do at the beginning of a trial. So you get all of the preliminary stuff done, and hopefully the clerk has done a good job of keeping all of those organized and ready. Again, there can be objections. There can be objections to PJC members and whether they should be recused. There can be various kinds of objections. And many attorneys like to ensure they have some objections, because if they don't get ruled their way, that can become part of what they build as a reason for an appeal. Evidence. D50701 defines evidence as, in addition to the testimony of witnesses, so testimony of witnesses is evidence, but also records, writings, material objects, or other items presented to prove the existence or non-existence of a fact. That's what evidence is. I see from Bill that the forms are available today, at least, at the bottom of OGA's Constitutional Interpretation Polity Resource page, and also available as PDFs. So I will take a look at those at some point and see if I think any updating needs to happen of them when I have that conversation with Lori. So what you're trying to do with evidence is prove the existence or non-existence of a fact, and you can use any variety of those things to do it. I think I said earlier that some of what I say, I'm saying for the purpose of attorneys, and some of it I'm saying for the purpose of people who are not attorneys. This one is for the non-attorneys in the room. Attorneys all learn this and get it, that there's a difference. There are several differences between kinds of people testifying and kinds of evidence being received, and different aspects of a case. So one of those is the difference between fact witnesses and expert witnesses. Fact witnesses are people who saw something. In a secular court, there were 3 people sitting at the traffic light in different places, and they have different perspectives on what they saw, whether the light was green or red or whatever. Those are fact witnesses who will be brought in to say, that person ran a red light, or that person didn't run a red light, or whatever. And they may dispute what that is, and they may agree or they may not. Expert witnesses are people who have expertise in some particular area, and because of that expertise, they're brought in to talk about it. There's a dispute over whether the light was red or green. Well, maybe there's a technician who can verify that it is physically impossible for that traffic light to have been green in both directions or red in both directions or something. So there could be some technical thing. Because those are different kinds of witnesses, they can be treated differently. Namely, that fact witnesses can be barred from attending the trial other than when they are giving testimony, or at least until such time as they give their testimony. That way they can't corroborate or change their story based on what somebody else says. Presumably, an expert isn't going to do that. On the other hand, expert witnesses have to be qualified. That is, before they can serve as an expert witness in a trial, the attorneys have a chance, or the counsel have a chance, to verify that they are in fact experts. So you can go over their credentials or have them answer questions and see whether you concur that they're an expert. And then you could challenge, if you believe that a person is not an expert, whether they should be allowed to be seated as an expert. And that's a matter on which the court could have to rule.